Okay. Hello, everyone. We are so excited to be here to talk about trends in open government litigation. I am Katie Graham, and I'm Newsroom Counsel at Bloomberg. You can see I'm sitting here in the newsroom at the moment. I cover all the legal needs of our newsroom, and that, of course, includes all of our FOIA and open government programming, including requests, appeals, managing litigation, and everything, and advice on everything in between. So I have some amazing panelists with me today who will introduce themselves in just a moment, but I think we have three of the most experienced FOIA litigators and experience with litigation in the country. So please, we want to encourage you to ask questions because we have things we want to talk about, but we are very happy to also talk about things that you've been wondering about or want to hear about in this area. So with that, I'm going to turn it over. We'll start with Gunita to introduce herself, and after that, we'll get going because we have a lot to cover.
Thanks so much, Katie. Yes, I'm Gunita Singh. I'm a staff attorney at the Reporters Committee for Freedom of the Press. We provide a pro bono legal services to members of the news media. We take a broad definition of news media. So whether you're at an established outlet or you're a freelancer or a documentary filmmaker, we're here to help you with your public records questions and your news gathering questions. And knock on wood, hopefully you won't need it, but defamation defense, subpoena defense, etc. And I've been focusing on FOIA and public records for about 4 years now with the Reporters Committee, and then a couple years prior to that. Really excited to be here with Matt and Alameen and Katie.
Okay, Alameen.
Hi there, I'm Alameen Sumar. I'm a counsel at the New York Times, based in DC, and I work on sort of newsroom related matters and general litigation at the company. I've worked on public records actually when I was a fellow at First Amendment fellow at the Times, but it's part of my work now, along with libel, subpoenas, general news gathering advice, copyright and fair use, and a host of other things. Really excited to be here. Thanks.
And I'm Matt Topic. I started a mostly FOIA media practice at a civil rights firm about 8 years ago after doing some pro bono FOIA work that I just sort of stumbled into while I was at a large corporate law firm. We're now a team of 4, about to turn 5 attorneys and 3 paralegals, and we have a docket of currently pending about 280 state and federal FOIA cases. It's a little more than half federal. The rest are Illinois state court cases and then some random other states. So I've seen a lot of different wrinkles of FOIA from a lot of different perspectives, and I'm very happy to be here today.
Great, thank you all. So I wanted to start the conversation on something of a high note, because I think a lot of the conversations around FOIA and open governments tend to fairly revolve around how frustrating the process can be, how it is not a super easy or successful process a lot of the time. But I think that, and whether or not this should be how it works out, I think litigation actually can be very successful. And I think you've all seen some pretty big successes once you get to that phase. So I wanted to hear your thoughts on that, you know, how litigation's worked for you and your clients, and, you know, where you're seeing the most success. And also, you know, along with that, kind of a recent favorite litigation open record success to share with the group here. So let's start with Matt.
Sure. So a number of years ago, I did the case in Chicago that forced the Chicago Police Department to release the Laquan McDonald shooting video. And that was the result of a Freedom of Information Act lawsuit. Quite a bit has happened in Chicago as a result of that. No one would say that policing has been fixed or is now fully compliant with the Constitution by any means, but it had political ramifications, it had legal ramifications. A police officer was convicted of second-degree murder as a result. You know, lots of things happened as a result of that. And then on the federal level, I did a case for Jason Leopold at BuzzFeed for to challenge the redactions to the Mueller report. And we got additional information released. It took an appeal to the DC Circuit, but we now know more about why Mueller did not charge Donald Trump Jr. with a crime, despite apparently having evidence to do so, at least with the misdemeanor. The really interesting thing there was we can get really sidetracked into the politics of these things, but it was a joint decision by all indications, both by Mueller's team and Barr's team, to withhold this information. So it wasn't like one was right and the other was wrong. They were both wrong. And I think that sums up FOIA for me, in a nutshell. And then the last thing I would add on that is we also did a case for the FBI 302s, the summaries of investigations from the Mueller case. And this was part of Jason's very broad effort to get everything released as possible from the Mueller case. And it's a long story, but is a result of presidential tweets that may or may not have been an effort to declassify records, which obviously has now become a very interesting subject. We forced DOJ to get a declaration signed by Mark Meadows based on a conversation he had with Donald Trump about whether those tweets were intended to be self-executing declassification orders. So, I know journalists try to not be the news, but it was sort of a really interesting twist on all that. And I think the lesson is you never really know where FOIA cases might take you, and they take you to some fun places sometimes.
Great. Alameen, do you want to go next?
Yeah, I'll jump in. And, unlike Matt's stories, my story of success is probably relies on an overstated definition of success. But it's sort of something that's happening right now. And I think, the story illustrates kind of the benefits of persistence and really sort of holding the government's feet to the fire in litigation. We're currently litigating a case in the Southern District. It's in front of Judge Rakoff against the FBI for documents related to NSO, the Israeli group that manufactures Pegasus, the spyware tool that's used by governments around the world, and which the FBI, as Christopher Wray disclosed earlier this year, purchased a license to use. He says they didn't actually deploy it in any investigations, but they purchased a license to explore whether to use it. We are suing over 2 requests filed by our reporter about NSO. And when we got, if you've been in front of Judge Rakoff, you know that he sets a very tight schedule and doesn't like making modifications to that schedule. So the government was on a very short leash and produced some documents to us, along with an 8-page Vaughan index, listing all of the documents being withheld in very small font. So there's a lot of documents at issue, and we submitted a brief opposing the government's motion for summary judgment, basically going through methodically, and a lot of the credit for this goes to other people on my team, but going very methodically through the government's claimed exemptions and withholdings and pointing out why they just didn't really stand up, even with the limited information that we have available to us. And in response to that, I mean, we're still in briefing, but the government decided to release additional documents to us, decided to give us another Vaughan index that has more information about these documents that are being withheld, and has agreed to run additional searches because we pointed out that they actually did a pretty poor job searching for documents, left out some obvious custodians and some obvious search terms. So I can't promise you that we're going to get any bombshell reporting out of these additional documents, but I think we've already kind of been able to set the tone in this case. And it's really the product of kind of being very methodical, being very careful, and challenging the government, because they're not always ready for that when you get to litigation. And when you push them, even before they get in front of a judge who, they don't want to get embarrassed, they're going to be willing to make sometimes additional disclosures. So again, strong definition of success, or overstating success, but I'm very optimistic about how this case is going to go.
Do you think that at the New York Times, having brought FOIA cases before, and the government knowing that you guys as an outlet are willing to sue, has helped your FOIA efforts, starting from just when you requested? Do you think you get better responses?
I think that it probably makes a difference at the AUSA level when you actually get into court. We have good, and this again, the credit for this goes to largely to my boss, David McCraw, who's been doing this for a long time. We have good relationships with them. They trust us, and they know that we are zealous litigators. And I think that actually does help, even with the judges too. But at the administrative level, I don't know how much of a difference it makes. I like to think so, but I think the U.S. The bureaucracy is so vast, and the number of agencies we deal with, they're so numerous that it's hard to tell. I mean, maybe there are individual cases where a FOIA officer has seen us before and is now a little scared, but I think it's hard to know. It's very hard to know.
No, I hear you. I think we'll go a little bit back to that idea in a second, but I want to give Gunita her turn to give her favorite FOIA success story and view on litigation generally as a tool in FOIA.
Yeah, thanks. There have definitely been a fair share of success stories here at the Reporters Committee, alongside all of the disappointment given the delays and denials that just are an endemic feature of the FOIA process. My favorite success story by far is with our beloved client, Azmat Khan, who won a Pulitzer Prize this year for her reporting on the true extent of civilian casualties resulting from the war on terror. And we have 2 lawsuits for Azmat Khan, 2 FOIA lawsuits. And, just getting into court and getting a production schedule in case has allowed her to get rolling releases of documents from the Pentagon, from the Department of Defense. And while, she's waiting for the next production, she's able to go to countries like Afghanistan and Iraq and Iran and do those on the ground interviews with families and survivors of drone strikes. And then we get the latest production, and then she's able to sift through them. So even just getting into court and getting those rolling releases has allowed her the opportunity to do this tremendous reporting that has fortunately been recognized. And I wanted to provide one more success story, because I think what success looks like in the FOIA context can be a bit nuanced. In 2019, some of you may remember that San Francisco area-based journalist Brian Carmody had his home raided by the SFPD, and he was questioned by FBI agents. Many folks on this call may know that there are pretty stringent criteria that law enforcement agencies at the federal level have to satisfy in order to use law enforcement investigative tools against a member of the news media when that questioning or that seizing of equipment relates to legitimate news gathering activity. So we submitted a FOIA request to the FBI, litigated to figure out whether those stringent protocols were followed. And because we essentially got no records in response to this FOIA litigation, it essentially confirmed that the paper trail we were looking for wasn't followed. So even though we didn't get that huge document dump that people often celebrate in the FOIA context, it confirmed that these FBI agents did not get the explicit Attorney General authorization that they were required to get in order to question this journalist. So success can look a little bit different depending on the situation.
Totally. And Matt, there's a question in the chat for you going back. I think you can see it going back to what Alameen was or what I'd asked Alameen about, being a frequent litigant, if that ends up being helpful pre-litigation, and maybe you have to bring less litigation. And I'm interested, I think the audience is interested in your view as Jason Leopold's lawyer. And I'm also interested because as for those of you who are not familiar with Jason, he's, I think, has the most FOIA requests ever, or currently outstanding for sure, of any journalist, I think maybe of anyone. And he recently joined Bloomberg, so now he is my client. And so I'd love to hear if you think we will, by having Jason here and you as well, on his, FOIA requests and others, if we're going to have to eventually maybe file more and then file fewer lawsuits to get agencies to comply.
First, I mean, Jason is really actually one of the nicest people I know, and which isn't maybe the reputation that some FOIA officers would attribute to him, but I think he actually has very friendly relationships with a lot of FOIA officers. They understand where he's coming from, and they appreciate, and I, in representing him, appreciate that he really understands the law very, very, very well. And so like this really sums him up pretty well. There's like a rider to his FOIA request that is pages and pages and pages long about instructions, and in almost everything in there is the result of something getting burned on something in the past, and then putting it into the form request so they can't do it the next time. It just kind of learning as you go. And I think, he's a great example then. I think that sort of to everyone on this Zoom, I would say, learning as much as you can. This is the last audience I probably need to say that to, but the better you understand it, the better off you are. So, when he's coming to us with denials, they're usually in pretty good shape. We use a phrase called FOIA hygiene. Like, have you checked all the boxes and done all the things that you need to do? And his are usually in very pristine shape. So that's the short answer to what it's like representing Jason.
That leads to another, we are going to get into more substantive trends, but that does lead into another area that I thought might be helpful to cover briefly, which is how to set up requests for the best shot of success if you actually end up litigating them. So I know with Jason, as you mentioned, he does really approach it like a research project, and make sure that he knows as much as he can. Sunita, are there any other tips that you've given through the Reporters Committee or that you've seen have been successful when you're bringing lawsuits to make sure that everything's set up from the beginning?
Absolutely. I'm a big fan of ensuring that FOIA requests are as detailed as possible. I'm a big fan of using, keywords, date ranges, senders, recipients, offices of origin, et cetera. These agencies are receiving dozens, if not hundreds, of requests a day. So the more you can do to kind of hold that FOIA officer's hand through the process, so they receive the request and immediately know, okay, this is the records custodian that I want to forward it off to, it's going to save everyone time and expense. But if you do eventually need to litigate, the cleaner the administrative record, the easier it's going to be for the judge, right? A lot of judges tend to hate FOIA cases because sometimes with less sophisticated requests, the administrative record can be a little bit messy. One tip that I've been really encouraging requesters to focus on is if you're going to include a background section in your FOIA request, I've started to note this background section is not intended to limit the scope of my request. And here's how that's come up. So maybe I'll do a somewhat of an exploratory type request, a fishing expedition, but I'm including keywords. I want all records mentioning these 5 keywords. But if I include in my background section, the general subject matter that I'm interested in, sometimes we've seen FOIA officers taking liberties where a responsive record is one that contains those 5 keywords, but they'll claim it's not responsive because it's not really what you're interested in. But I know what I'm interested in, and it's records containing those 5 keywords. So just make sure you're covering your bases, whether it's, this background section is not intended to limit the scope of my request, or whether it's, ensuring that you're using a date range that's really going to encompass what you're most interested in, things like that.
That's great. I think it is helpful to be as specific as possible, and we've been trying to, as Matt, we've been trying to increase our FOIA hygiene to make sure we're set up correctly. I actually do want to turn, because I want to make sure we have enough time, to what we're really here for, which is the trends we're seeing in open government litigation. So I think one of the biggest topics, and there was a panel on this, though happily they didn't really talk about the litigation aspect as much, so I'm glad that we can, is police records. And I was hoping, Sunita, you could start again just with kind of an overview of what's happening in this area, because I know Reporters Committee is doing so much in this area, and that you have quite a few cases, and just what you're seeing there in terms of kind of where we are, like what's being litigated now, what's been settled, and what we still have to fight about.
Absolutely. This is a topic that could take up an entire treatise. So I'll do my best just to kind of give a bird's eye view. There's, of course, tremendous variation across the states when it comes to the availability of law enforcement records. For example, use of force reports, body-worn camera footage. These are sorts of records that are subject to varying degrees of openness across the country. One general rule of thumb is if a law enforcement record implicates an ongoing investigation, then generally those may not be subject to disclosure, at least for now. Also, some states tend to withhold personnel records of government employees, which of course can include police officers. But there's absolutely a trend that continues to inch toward increased openness when it comes to disclosure of law enforcement records. And the Reporters Committee has a pretty robust amicus and litigation practice in this area. And an exciting development came from this spring, where just days apart, the New Jersey Supreme Court issued super pro-transparency rulings in police records cases. So I'll focus on two of those. One of them was called Libertarians for Transparent Government versus Cumberland County, where the New Jersey Supreme Court ordered the release of a settlement agreement reached between a county in New Jersey and a corrections officer who had been accused of sexually abusing several detainees. And this was a pretty significant case because the agency permitted this corrections officer to retire in good standing, even though they had told the press previously that they disciplined him. So it really underscores the importance of getting access to these records for ourselves so we can understand what happened. And then in a similar case, Rivera versus Union County Prosecutor's Office, the court concluded that an internal affairs investigation that information from an IA investigation into the Elizabeth, New Jersey Police Department director's use of racist and sexist slurs had to be released under the common law. And that was pretty significant because IA records, as many of us know, are just notoriously withheld and commonly cited as being among the most secret, category of law enforcement records that exist. So the fact that the court said, okay, there's OPRA, there's the Open Public Records Act, which has certain contours, but then there's the common law, where it's a straight balancing test. Does the public interest in this information outweigh any privacy interests? And the court determined absolutely. And now there are these factors known as the Rivera factors, where the New Jersey Supreme Court said, you can look at the nature of the alleged misconduct. Was it substantiated? The nature of the discipline imposed, the nature of the official's position, the seriousness of the misconduct. All of these are factors that we can use to weigh whether the public interest in disclosure outweighs any privacy interests. And I really think that part of the court's ruling was informed by the landscape in other jurisdictions. Alameen in a few moments, I believe, is going to talk about the repeal of 50A in New York. There's not a doubt in my mind that the neighboring jurisdiction of New Jersey was influenced by things that are happening, right next door, because judges don't want to be outliers. So it's really, really exciting that we're seeing increased transparency within the context of law enforcement records. And, with body-worn camera footage, legislatures in Maryland and Colorado and Wisconsin over the last couple of years have similarly moved to increase access to these types of records. So I think by and large, we're headed in the right direction there.
So Alameen, can you let everyone know what Gunita is referring to if they don't already with the repeal of 50A and how that's what the New York Times has been doing in that area?
Sure. Yeah. I think a lot of the folks on this call will already know some of the background, but in November 2020, Section 50A, which has been part of New York law for decades, a law that, on its face protects the personnel records of police officers, correctional officers, and others, and had been interpreted very broadly to apply to, all disciplinary records, even precluding release of redacted disciplinary records that would not identify officers, was repealed. It was actually kind of stunning that it happened that way, because it's something that people had been lobbying a long time to get rid of. And, I feel like I remember reading about it and we were sort of shocked. It was like, okay, the legislature was passed this, the governor was signing this is going to happen. And there were kind of two phases to the litigation. There was sort of an early phase where the police unions, who was sort of were taken by surprise a little bit, started filing lawsuits, injunctions to prevent state agencies from releasing any of this information, basically saying you have no discretion. And there was litigation brought against the CCRB, the Civilian Complaints Review Board, which the Times was involved in, where the CCRB actually did release some of this data before the unions could bring a lawsuit. And then the unions were in the position of having to spin that there was a conspiracy, going on between reporters and the CCRB. But the courts sort of, resoundingly rejected their legal argument. Basically, the idea that the unions can contract with government agencies to override the public's right to information under FOIL, that's really just never been recognized as a part of, New York law, and in other jurisdictions too. Private parties cannot contract away the public's right. So, the unions lost in that phase of litigation. That went all the way up to the Second Circuit. But what's happened since then is litigation around whether this information is actually going to be disclosed. The agencies have authority to release it if they want to, but they are asserting privacy exemptions. And in some cases are asserting that 50A does not apply retroactively. So the privacy exemptions are being deployed in cases where requesters are seeking information about allegations that maybe haven't been substantiated. And the retroactivity argument is basically that, any records created before the date 50A was repealed are still protected by, what was then 50A. This only applies prospectively. And we've seen some courts reject those arguments, but we've seen some courts buy into them. I think the unions have created this, one of the things that underpinned 50A was the idea that if you release information about this, police officers and others are going to be harassed. And I think the unions have actually succeeded in convincing the courts that that is a real risk when it comes to unsubstantiated allegations. I think what's troubling is that, even if that's a consideration in some cases, the courts seem to just sort of categorically, say, well, it's unsubstantiated, so there's a privacy exemption, rather than weighing the public interest in knowing what were those allegations and how were they investigated. They weren't substantiated, but the whole point sometimes is understanding what the government process was that labeled them substantiated or not. The retroactivity argument, I think, is just bonkers, and I think will be rejected by the appellate courts, hopefully, when it gets to that point. So I think the jury's still out on what the long term is going to be, but we won the initial fight. This other fight continues and probably, will go on for a while.
So I think both of you identified some of the issues that came up on the earlier panel. What kind of weighing of the privacy interest should there be? And I think New Jersey kind of is spot on, because obviously there probably are some instances where there is a privacy right that does outweigh the public interest, depending on the misconduct alleged, et cetera. But that should be weighed, and should not just override it automatically, which is happening. And then the other thing was that you mentioned is the union's arguments that these are unsubstantiated allegations. And there was some really interesting discussion on that as well, for those that weren't there, on that if they don't have to release, if they only have to release the instances where an officer was, where it was adjudicated that there was misconduct, I mean, it really decreases the chances that misconduct will be found, because if you don't find misconduct, then you don't have to release the record. So it's really not, that I hope will be not found to be a reason to keep it, keep things private, as I know this is going on in many states. Matt, and I know you have some cases in this area too, so I'd love to hear from you, especially on another topic that came up earlier, which is privacy concerns for the video footage that comes out, and how courts are dealing with arguments that, either there are these privacy concerns that can't be addressed, or that, I think also there's issues with, just exorbitant fees being assessed for, redaction of video, even though we all know that can be done pretty easily. So yeah, if you could talk a little bit about your cases and experience with these kinds of records, that'd be great.
Sure. So we do run into this all the time, where there might be a third party, who's just happens to be in the background in some video in which there was some police use of force or an arrest or something like that. So our body cam statute, I think, was largely drafted by the ACLU of Illinois, or was heavily involved in it, and is an attempt to balance that. And so it has a very it's not Byzantine, but it's a rather extensive analysis for how you deal with that. And it depends on, if the concern is, what if police officers are just walking around with body cam running and just archiving vast amounts of video of people just out in the world? And so one requirement is that for the video to be releasable under FOIA, it has to be flagged, meaning that there was a use of force, there was an arrest, there was a citizen complaint, there's a variety of criteria. And then there's differences on whether it was in a place with an expectation of privacy or not. So if it was a witness interview that occurred inside someone's home or a raid inside someone's home, that's a different analysis than if it's out in a public place. The other somewhat related thing I'm running into, not so much with body cam, but more with stationary video cam, is, and I'm sure this is true in many places, but we have exemptions for like security measures that, if released, would jeopardize systems intended to keep people safe. So we lost a case where it was video from a public transit train station where someone had been pushed onto the tracks. And the argument was that if we released the videos, that a terrorist could figure out where all the blind spots of the cameras are, and then that would jeopardize the security of the system. And we won at the trial court and we lost on appeal, which in some ways just proves, if you say terrorism to a judge, maybe particularly a state court judge, it's a whole different set of analysis. So we're still trying to figure out how broad that's going to go. We have some cases involving inside of prisons and inmates who allege they were beaten by guards or things like that. We're getting the same kind of arguments. I'm not sure how they think that people inside the jail are going to be able to watch the videos, if they were able to even get them. So there's a lot of inconsistencies, but those are all issues that we've run into with videos.
I see in the chat that Jeff Roberts had mentioned that Reporters Committee recently helped enforce Colorado's new body cam footage law, which I didn't know they had a new law. Gunita, do you want to talk about that? I don't know if you were involved in that case at all.
I was not involved in that case, but I will use this as an opportunity to plug the Reporters Committee's local legal initiative. We have attorneys in Tennessee, in Colorado, in Oklahoma, in Pennsylvania, and in Oregon, where we are really helping local newsrooms, established newsrooms, fill those gaps that we were made aware of when we were doing our request for proposal. Where should we place attorneys throughout the country, and in jurisdictions where we've got new laws on the books? It's super important to make sure that the courts are interpreting them in a way that kind of honors that presumption of disclosure. So I'm just so delighted to hear that we've got someone, that Rachel Johnson, our Colorado-based attorney, was able to help.
That's great. Yes, we love the Reporters Committee. even for us, where we have a lot of resources, they are a huge help in everything. Okay, so I think let's switch topics a little bit, or a lot, to another trend that I think we discussed as seeing, and partly because of new technology. And a lot of this obviously has had some high-profile cases, but also some smaller ones, which is private emails and text messages, which is kind of one piece of it, and then disappearing messages, which is kind of taken to the extreme. Obviously, all of these apps, probably a lot of us have many of them on our phones, but we're not government officials, or actually some of us are not on the panel, but attendees. So it's kind of a fact of life, to mingle these kinds of communications. So I was interested in hearing if any of you have been litigating these issues, or just if you know about other cases, and how are courts dealing with this. Are they holding agencies' feet to the fire to make them really do these searches on these, let's put disappearing messages aside for a second, but do the searches on private servers and things like that? Or are they kind of baffled on what to do? Matt, do you want to start on that one?
Yeah, happy to do that. So the last time I looked, I think every state that has addressed the question of whether emails or text messages on private or non-governmental accounts that pertain to public business, whether those are public records, every state has found that they are. There were some, I think California had a appellate court decision that said they were reversed by the California Supreme Court. There might have been states where there was a bad judicial decision and then the statute got rewritten. I haven't looked in a little bit, but I'm pretty confident the answer is there is no state that says you can just opt out of FOIA by which email account you decide to use to transact public business. So I think that's working its way through. There are still states that haven't addressed it, but I think that's worked out pretty well. Then there's a variation on when you're potentially entitled to a search or an inquiry for those. So some federal courts are saying, because the government's rules are you're not supposed to do that, and if you do that, you're supposed to forward it into a government repository, because of the presumption of regularity that presumes that government officials comply with the law. Don't let me get started on that subject. Because of that, if you don't have some tangible evidence that someone's using a private account or whatever, then the government the agency doesn't even have to ask. I don't think that's really that's a troubling standard to me. Sometimes you can figure that out. If person A's Gmail address is on person B's government email, but that can be kind of a hard standard to really be able to satisfy. We don't typically do that. I mean, you don't have to show that someone used a government email account, right? I mean, it's it's not that hard to ask. So, that sort of takes me again, I guess, to the next question is, okay, if they are subject to FOIA, then what's the process for dealing with this? And what mostly seems to happen, what's happened in Illinois, is the agency has an obligation to make an inquiry as part of their search, which means they at least have to ask. Like, we would get the police unions and others jumping in trying to say, the government can't go rummaging around my Gmail account. I shouldn't have to give them my password and username. And like, well, nobody's saying that, but they're entitled to ask, and you have an obligation to answer as part of your job. And if it comes to it in a lawsuit, you might have to sign a declaration, or at the very least, the FOIA officer has to sign a declaration saying that you said you didn't have anything. So we've had a number of cases where that's come up. That can be a cumbersome process. I've got a case where there's a number of police officers. Some of them are retired. We had to try to get their last known addresses from the retirement system. Like, that can be a slog to try to work through. So that's the logistics, I think, kind of we're still working out. And I have cases where the police union intervened and basically said, we're telling our members not to answer that question. And so now that's going to be up in front of the appellate court. So those are some of the issues I've seen with private emails and text messages.
Alameen or Gunita, do you guys have anything to add on what you're seeing in this area? No.
I'll briefly add on to what Matt was saying, which was, I think a helpful analogy here can be made to databases, right? As technology continues to evolve and government's dependence on that technology continues to deepen, it's really important that public records statutes keep pace. And I think we're seeing them keep pace in certain respects. Matt mentioned that any court that's looked at the issue of, do text messages constitute public records when they relate to public business? Yes, of course. But I'll also note that Georgia's public records statute explicitly mentions text messages. So that makes me happy, just because I love, erring on the side of over-inclusivity. But with databases, we've seen certain courts say that querying a database in order to respond to a FOIA request doesn't constitute the creation of a new record. And I love seeing those sorts of opinions drop, because it really drives the point home that as technology continues to evolve, we can't use that technology as a means to circumvent access to records. We actually need to lean on it in order to increase access to public records. But I'll also say that even though we're seeing some positive developments on that front, I mentioned earlier, erring on the side of caution when you're phrasing your records request. If you're including a background section, then say it's not intended to limit the scope of your request. I would also reiterate, cover your bases when it comes to, if you're seeking certain communications, maybe specify this applies to emails sent on a non-government domain. This applies to messages sent on apps such as WhatsApp or Confide, et cetera, because I like to give public information officers the benefit of the doubt, but we've unfortunately seen examples where, personnel are using these apps in order to evade their responsibilities. So I would just encourage you all to be vigilant in the very text of your request itself.
That makes sense. I don't know if you had thoughts. We had one question going back to the discussion of 50A based on just the timing, because it was amended and then the amendment was partially revoked. And I don't know, you got into this a little bit with whether it applies retroactively, but is it a little more complicated than that? And I don't know if you know the answer, whether the date of the request submission is going to matter, or if it, eventually will be retroactive, if we're still fighting that. I don't know if you had thoughts on that question.
Yeah, I actually, the partial revocation of 50A hasn't really come up for us yet. I haven't seen it kind of affecting our entitlement to records. What I would say is, like, you probably have to just look very closely at the text of the statute or, the legislative amendment to see, does it say anything about retroactivity? Does it say, this doesn't apply to documents created before, the date of this enactment? I think if you have that, and I don't know if the March 2022 partial revocation says anything about that, but that's very different than, with the repeal of 50A, there wasn't anything like that. I know that this came up too in California because there was an important change to the law on law enforcement records. I think the courts came out over there against the idea that the law did not apply retroactively. And I think that is the law in New York, or at least should be, that if the law doesn't say anything about it, then, the legislature is presumed to be saying all these records are now open to disclosure. They don't have to explicitly say this law applies retroactively. It's really, the presumption is, if you don't say anything, that's the state of play. But we'll see if the courts agree with me on that. My hot take on retroactivity.
Yes, thank you. I'm going to stay with you for another second as we kind of switch gears to some issues that mostly apply in the federal context. With the FOIA Improvement Act, which now requires foreseeable harm to apply for denial, it can't just be that the exemption applies. There has to also be foreseeable harm, which the agency has to show with some specificity. I wanted to get your take on whether that has actually, whether you're seeing that in practice, are agencies actually showing foreseeable harm, or is that something that has really, you're having to litigate?
Yeah, I think, this FOIA Improvement Act was enacted in 2016, and there was a sort of period of time when you didn't really know what the effect of this particular part of the act was going to be. And I think, thanks to good work by many people, including the Reporters Committee, this is starting to have some teeth. We're seeing courts say, including the DC Circuit last year, that this actually means something. Like, Congress enacted this for a reason, and the reason was that withholdings, particularly under Exemption 5, are very broad, and so we want the agencies to go a step further and tell us not just that the information falls within an exemption, but also that we foresee some harm from disclosing this to the interest that the exemption is meant to protect. And at least in DC, I think in New York is maybe less clear on Exemption 5. Exemption 4 is more interesting, and we can talk about that. But at least in DC, the case came out last year, brought by the Reporters Committee, stands for the proposition that you have to be specific, you have to be concrete. You can't just gesture at the broad types of harms, that, like, this is going to, for Exemption 5, deliberative process privilege, this is going to have some chilling effect. You have to be specific about why these records are going to have that outcome. And so I think that is starting to filter down to the agencies. We're seeing that in litigation, and we are actually taking a case to the Second Circuit right now, where we are suing the Department of Justice for a monitor's report created pursuant to a plea agreement in the Volkswagen litigation. There was a criminal case brought against Volkswagen over the emissions scandal. There was a plea deal reached, and part of the deal required Volkswagen to have this independent monitor make sure that they were complying and then produce a report. Very small portions of that report were released to us by the district court, and we've decided to take this to the Second Circuit. Volkswagen is involved, and exemption 4 is a big issue also. I know we'll talk about that. But one of our main arguments is going to be we don't think the judge applied the foreseeable harm standard rigorously. And I think the cases, some of the cases in DC and some of the other cases sort of in the district courts in New York give us a pretty strong basis for making that argument.
Matt, I know that you have also been litigating this issue, and especially, well, I think in the deliberative process context, because I think, as Alameen was alluding to, that's kind of where the government is getting the most deference, even without necessarily articulating the foreseeable harm that they're supposed to. But I believe I was told by Jason that you recently got a good ruling on deliberative process. So I was hoping you could talk about that.
Sure. So anyone who litigates a lot of FOIA cases is familiar with the phenomenon by which the government gets do-overs. So it's their burden of proof, and no other litigant ever gets a do-over. If you bear the burden of proof in a federal lawsuit and it's summary judgment time, it's called put up or shut up. Literally, there's cases that say that. The government, though, gets to try again. And so we had a case for a bunch of deliberative things, and the judge said, we briefed it and we pointed out why all the showing was inadequate, both under substantive deliberative process law and especially under foreseeable harm. And I think it sort of just turbocharges in some ways a lot of the things that are already in deliberative process, and it really requires a lot more specificity, and they didn't provide specificity. And the judge told them, this is all the things that are wrong with your declarations. You get another chance. So that's really frustrating, but we do it again and they don't fix those things. And so the judge is like, enough, like, I'm not going to give you a third do-over. I told you what you had to do and you still didn't do it. So that's a kind of extreme case, but I think, foreseeable harm definitely gives you more, it's the specificity part of it that I think really is particularly helpful. I mean, they can articulate the harm. That's not hard to do. They can, to use Alameen's words, they can gesture at what the subject matter of the request is. Some courts will let them just stop there and get away with it, but the courts that are doing a better job are really like, no, you got to connect those things together. What is it about this specific subject matter that makes it foreseeably likely that there would be a chilling effect? The super interesting thing is we don't have any guidance that I've seen from any courts on how you make that determination. What are the factors and circumstances under which harm is more or less foreseeable? What tends to happen is if it just seems stupid, then the court can use foreseeable harm as a way of saying, like, who can, like, just believe this is about something dumb. Well, if you're a reporter, sure, you can report on things that are dumb, and government dumbness can be very newsworthy. What I want to kind of push forward and what I would suggest is that the whole idea of chilling around deliberative process, which is the main harm, that future government decision makers and deliberators will not be forthcoming if they know that their initial preliminary opinions are going to see the light of day, which to me translates into government officials will allow bad things to happen to the United States because of a suboptimal decision that was made because I wasn't willing to risk my own reputation to be straightforward with the deliberators about some decision to be made. And what I would say when you couple that with the presumption of regularity and all these other benefits we give to the government is the bigger the stakes, the less likely that harm is foreseeable because a government actor isn't going to allow terrorists to bomb the United States rather than let their initial opinions about counterterrorism measures, be released to the public. So whether that will work, I have no idea, but that's I think the next level now on foreseeable harm is, all right, now what are the considerations that we use to decide when it is or isn't more foreseeable? It's always easy to do it's not specific enough. It's more if they are specific enough, how do you challenge whether that harm really is likely?
So I want to segue before we, because we're like almost running out of time, into exemption 4, which was mentioned a few times in the foreseeable harm context. Gunita, I was hoping you could talk a little bit about exemption 4 after the Argus case, which made it easier for companies that provide records to the government to assert a confidentiality interest and an exemption from FOIA. Has it resulted in less disclosure? I think after that case, a lot of us were worried that it was just going to make it super easy, but I'm not sure those fears have actually been realized. So hoping you can discuss that a little bit.
Yeah, sure. So briefly, the case that you referred to, Argus Leader, Food Marketing Institute versus Argus Leader, the Reporters Committee actually submitted an amicus brief in that case, and it had to do with the Argus Leader media's fight for information about how much revenue retailers earn from the SNAP program, the Federal Nutrition Assistance Program. And in the summer of 2019, the U.S. Supreme Court issued an opinion in that case, which essentially made it easier for companies to keep information that they submit to the federal government private. And the court basically said that when determining the scope of confidentiality as it relates to exemption 4, if the commercial or financial information at issue is actually and customarily treated as private by its owner and provided to the government under an assurance of privacy, then the information is confidential within the meaning of FOIA exemption 4. I remember, putting myself back in that headspace and feeling some trepidation about how this is going to affect the public access landscape. But we have to remember that the FOIA requested issue in that case predated the foreseeable harm standard that we were just discussing. So my personal opinion is that the opinion is somewhat dampened, somewhat weakened by the fact that we now have this change in the law that Alameen said is now starting to really have some teeth. Because while we do have more cases analyzing the foreseeable harm provision as it intersects with the deliberative process privilege, I think the vast majority of cases interpreting foreseeable harm have to do with exemption 5. We're starting to see more cases trickle down about FOIA's other discretionary exemptions, including exemption 4, where we're seeing that provision do some additional work. I still think it's left to be seen how exactly it's going to intersect with exemption 4 in terms of, are we going to see a resurrection of the competitive harm standard in terms of, what is the foreseeable harm that the government has the burden of articulating when it comes to these particular types of records, instead of the whole, chilling agency candor thing that we've been seeing, time and time again for years now. But I'm not too concerned about the impact of Argus Leader at this juncture.
I think we just have a few more minutes, so I just want to touch on another topic that we were discussing as we were preparing for this panel that I think has also been coming up quite a bit, which is the reasonably described requirement on behalf of, for requesters to reasonably describe their request, and how courts, well, I guess how agencies are potentially misinterpreting that to just mean that it might be burdensome, but how courts are dealing with that once it gets to litigation. So Matt, could you talk a little bit about that?
Sure. So if you take the reasoning that the Supreme Court used in Argus Leader to remove any competitive harm requirement and you apply it to the term reasonably described, there's only one conclusion, and that's that all that matters is the clarity of the request. It doesn't matter the burdens involved in searching for the records. It doesn't matter the burden involved in processing the records. There's some DC law in other jurisdictions too that sort of try to contort reasonably described into something about the scope of the request or the work involved in processing it. And I think that should be an interesting question. Something I'm going to try to push forward is no, reasonably described just means, is it clear? And that means there really isn't a provision in federal FOIA to address burden as a whole. Now, I would not suggest to people, let's litigate over requests for billions and billions of pages of records, but at the same time, the agencies can be very overly ambitious in how they describe the challenges involved in searching for records, especially. So, that's an issue. In general, I suggest to people, try to use search term-based requests, is to the point that Kunitha made at the beginning, because that also removes this level of responsiveness review that can slow things down too. It's just, don't even give any background or any context. I just want everything from these people with these search terms on this date. There's no further analysis you need to do. If it hits, give me the record. If it doesn't, it doesn't. So I think that can move some of these kinds of issues.
Great. Well, I think we just hit 4:55. I was asking if we had 5 more minutes or not, because there's definitely more to cover, but we can continue the conversation next year or at another time. So thank you all so much. I think this was great. I think I was going to say, if anyone has questions and wants to throw them in the chat really fast, we can get back to you at a later time. But thank you all very much for attending, and thank you, panelists. I think this was a great discussion.
Thanks a lot.
Thank you.